The next case set for argument this morning is In Re RP. It's case number 19AP0037. Both parties are represented by counsel, so each of you will have 15 minutes to present your arguments. The appellant may reserve up to 5 minutes for rebuttal. I've got the clock up here, so let me know, and I'll interrupt you or let you know as you're getting close to that. Of course, we use initials for children because the arguments are videotaped and played on the court's YouTube channel, so please just use initials and keep your voice up since we want a good recording as well. Now, the court has read the briefs and we are prepared to proceed if you are.
Yes, sir. Thank you.
How much time would you like?
10 and 5, please.
I'll let you know when you get close to that 5-minute mark.
Okay. Thank you. May it please the court, my name is John Johnson. I represent Robert and Karen Baumgartner. They're the grandparents here today. The grandparents of RP. As you know from reading the briefs, this case is a juvenile court custody matter. And the basis of this appeal is that the court granted legal custody of RP to a person named Chandra Ridenauer. Chandra Ridenauer was the fiance of RP's father. Okay, Baumgartner's the grandparents. She's the fiance of the deceased father, and it's our contention that the court erred in a number of ways. First, it's our contention that the court issued its decision against the manifest weight of the evidence, and that it clearly lost its way in coming to the conclusion that it was in the best interest of this child to be placed with Chandra. And we're also arguing that the court abused its discretion in a number of ways. First, because the decision was not supported by competent, credible evidence, and procedurally, the court acted in an arbitrary, unreasonable, or unconscionable manner in this case. So, the arguments are largely evidence-driven, so this is kind of an unusual appeal. In the manner of the argument, it's going to be more like a closing argument, and I'd like to focus on the facts here. Procedurally, the case began whenever RP's father, clear back in 2017, filed a motion for custody of RP. That was ultimately heard and decided in September of 2017, and he received custody of RP at that time. RP was born April 23rd of 2014, so she was about 3.5 years old at the time the father was awarded custody. For the next 11 months, RP resided with the father, but she had constant, regular visitation with her grandparents, the Baumgartners. In August of 2018, the father committed suicide, and 3 days later, Ms. Ridenauer filed a motion for emergency custody with the juvenile court. And when she filed for emergency custody, she did not comply with the local rules. She did not support her request with a motion or with an affidavit stating any facts that suggested that there was an immediate danger to this child. And in fact, at the time she filed her motion, RP was with her grandparents, the Baumgartners.
Now remind me, from the 9/17 up until the tragedy on 8/18, was Miss Ridenauer living with the father and raising the child?
Yes, the father and Ms. Ridenauer were living together, and the father had custody of RP, so that is...
Their relationship was
yes
in place at that time?
That's correct.
Okay.
I would note, however, that at the time RP was born, Chandra Ridenauer was not in the picture at all. And in fact, at the time RP was born, she came home from the hospital to the home of the Baumgartners. She lived with the Baumgartners and her father and her mother, Alyssa Baumgartner, at the home of the Baumgartners for some time. The father moved out of the home, and then RP continued to live with her mother and the Baumgartners for about the next 3.5 years of her life until Dad got custody in September of 2017. So we're not talking about a situation where we've just got a couple of, satellite grandparents out there who see the child on a holiday basis. RP lived with the Bumgarners, and there was no dispute about that in the evidence. So, father dies August 10th of 2018. August 13th, Chandra Ridenauer comes to court, files this motion that is not in compliance with the local rules, and gets an order of emergency custody. The court schedules a hearing on that motion for emergency custody to take place August 23 of 2018. On August 14, the Bumgarners filed a motion for custody. Okay. August 23, we all appear for the hearing that had been scheduled by the court on the motion for emergency custody. But no evidentiary hearing occurred on August 23rd, 2017. Instead, that time slot was devoted to discussions about who were proper parties to the case, whether there had to be motions to intervene filed. And in fact, there was a schedule then in place requiring the parties to file briefs on this idea of intervention. In the meantime, at the conclusion of that discussion, the court continued the emergency custody with Chandra Ridenauer. Well, the Bumgarners filed a motion to vacate the order of emergency custody on the basis that the local rules hadn't been complied with at all. There had been no showing that this child was in any sort of danger, was in imminent risk of harm, if there hadn't been an order granting emergency custody. And because of those facts, it was the Bumgarners' position that that order was improper and should have been vacated. The court summarily denied that motion the very next day. The motion to vacate was filed on August 27th, and it was denied without hearing, without any sort of discussion or explanation on August 28th of 2018. And since then, RP has been in the custody of Chandra Ridenauer. And ultimately, when the case was heard in December of last year by the magistrate, and then decided in January of this year by the court, the child has remained in Chandra Ridenauer's custody ever since. However, we would note that the court did grant the same type of visitation arrangement so that the child was able to continue her relationship with the Bumgarners. So that is the kind of the procedural backdrop, or the statement of the case, if you will, of what brought us here today. The reason that we are arguing that the court erred in granting the legal custody of this child to Chandra Ridenauer is set out in our brief, but it kind of boils down to a couple of things. First, the court seemed to just give very short shrift to the relationship, the historical relationship that RP had with her grandparents, with the Bumgarners. She lived with them. They took care of her as if she was their child. They continued to do so. Whenever she was home from the hospital, that was the only home she knew. She has her own bedroom, her own toys. They fed her, they clothed her, everything that a parent would do, they did. And most importantly, from a historical context of the relationship, they are her grandparents. The court didn't seem to care about that in its decision. In fact, the court basically said, well, they start out on the same footing as anybody else. There's no statutory case law that says that they get a leg up in a custody fight. And while that may be true, okay, it still doesn't, you cannot ignore the fact that they are still her grandparents with a relationship with her that exceeded the period of time that Chandra Ridenauer even knew RP. And that's a big and important factor that the court should have given more weight to. Now, another avenue of argument here has to do with the idea of what's in this child's best interest with regard to the living arrangements, okay? You have to remember, the Bumgarners, as the evidence showed, they've lived in their own home for years, 25 or 26 years at this point. They're lifelong residents of Orville. There are relatives in the Orville area. child is employed. He's been employed at the Shots Organ Company for essentially his entire adult life. Karen is employed for Wayne County. She's worked there for 25 or 26 years. We have a stable home. We have stable income. We have people who are able to and have provided an excellent home life and support system for RP. They're both in good health. They're able to work, and they do work. In contrast, as the evidence showed, Shonda Ridenauer has not been employed since May of 2017. She left her last employment due to health concerns, a back injury, according to her testimony. She has no regular source of income except what she's receiving from Social Security for the death of.
I'm going to pause the clock just to let you know you're at 5 minutes now, but you're free to go on. You'll be into your rebuttal time.
Right, yeah, I was trying to do 10 minutes of regular time and 5 minutes of rebuttal. Okay.
You've got a total of 5 minutes left.
Okay, great.
So you're at your rebuttal time right now.
Oh, you've been already talking for 10 minutes?
Yeah.
Holy
I mean, you're free to go on, but I just want to let you know you'll be using your rebuttal time here.
Okay, well, that's the problem with talking about facts and court of appeals are.
I'm going to start the clock if you want to continue.
Sure, I'll just really briefly talk about the abuse of discretion
All right.
stuff, because you can read the.
I told you I was going to interrupt you, so.
And I do appreciate that.
Go ahead.
The abuse of discretion portion of this argument has to do with the way that the court dealt with the emergency custody issue, okay? The court has local rules, as you know, okay? The local rules require certain things to occur before the court grants an emergency motion for custody. Those things did not occur. There was no affidavit, there was no showing of immediate or irreparable harm, and the court granted the motion anyway. When we raised that issue as a motion to vacate, the court just said, yeah, we deny your motion.
Didn't the court say some of this was waived?
That's what the court said in its decision. That's correct, and we take issue with that. The court said we didn't object and we didn't file a motion to set aside. The fact is we filed a motion to vacate that order, which was summarily denied. So the idea that we waived anything, that just doesn't fly. We did what we needed to do. Go ahead.
And you're in your rebuttal. I really hate to ask a question now, but but the thing is, I'm wondering, why does this matter that they did it the wrong way to begin with? Because now the court has determined that the child's the best interest issue.
I think the reason that makes a difference is because that enabled Ms. Ridenauer to be able to argue, as she did, don't change the status quo. Okay?
Well, and I understand that, but how does that, the whole point is whether it was a mistake, whether it was the wrong decision, whatever, how does that impact the best interest of the child now?
Well, I think it impacts this idea that the court acted in a manner that abused its discretion. And if it's abusing its discretion, then that undermines the whole fairness of the proceeding. At least that's the way I'm reading the abuse of discretion cases. So that's where we're coming from with that. And with that, I'm assuming I have like a minute and a half or something.
You have actually 3 minutes and 15 seconds.
So I'll sit down and let Attorney Hart go ahead and proceed.
And that's what you'll have for rebuttal, so thank you.
I appreciate it. Thanks.
And counsel, you'll have 15 minutes.
Good morning, may it please the court. I'm Attorney Brad Harp. I'm here on behalf of the appellee, Shonda Ridenauer. I want to talk about two things starting off this morning. First, I want to address sort of the background of the case, and second, I want to address opposing counsel's arguments. In this matter, the case was Shonda Ridenauer filed a motion for emergency temporary custody, for legal custody. Hearing was held. In that matter, obviously, the burden is on the movement, plaintiff in those issues, burden, preponderance of the evidence. Court granted that motion and those complaints. The standard would be, was that against the manifest weight of the evidence? Meaning, did the fact finder lose its way and create a manifest miscarriage of justice? And in this case, that did not occur because there was ample evidence to show that it was in the minor child's best interest for legal custody to be granted to Ms. Ridenauer. I strongly disagree with what opposing counsel has said here this morning. This is not the time for a closing argument. This is not the time to relitigate this case, to talk about what was granted, what wasn't granted under the local rules. That's totally inappropriate at this time. I want to talk talk about the initial motion that was filed by Ms. Ridenhour. That is an emergency. The death of a custodial parent does give rise to an immediate or imminent risk of harm to that minor child. So that is an emergency. And pursuant to the court's local rules, a hearing was held. A hearing was held pursuant to those local rules within 10 days.
Ex parte hearing or?
No, a hearing,
Go ahead.
a hearing with both parties present, represented. I may have the timing on the days off a little bit, but I know that a hearing was held to address that emergency order. And as the court has sort of alluded to this morning, there's no prejudice to appellant in this matter because the child's going to have to be somewhere. Whether it's staying with Chandra, where the child had been residing since the father got custody back in 2017 with Ms. Ridenhour, or moving somewhere else, a decision would have to be made. And there was no, as the juvenile judge noted, and as this court has sort of alluded to as well, there was no motion to set aside the magistrate's decision with regard to what happened. Appellate kept going back to that emergency motion, and as I've said, it is an emergency, and the hearing, the matter was heard.
Now, was that the hearing where opposing counsel said the court, in lieu of having a hearing with testimony, just discuss who the proper parties were? And
Yes.
so was there a hearing, or was there just a discussion as to who's going to intervene in this case and who are the proper parties?
Yes, that's the hearing I'm referring to, and that's the hearing, that's when everybody is there to discuss what's going on. And it's my position that, as I'm saying, what I'm trying to get to is appellate can't show any prejudice from that hearing. Even if the
Wouldn't the issue at that hearing be whether or not the child is in imminent danger and an emergency order needs to be put in place? Was that issue ever addressed at that hearing?
That is the issue, and that's what I'm saying. Even if that wasn't handled properly, which I don't concede, but let's say for the sake of argument that wasn't done properly, that there wasn't a specific hearing on that issue, the child's still going to have to go somewhere, and appellate can't show any prejudice that they would have prevailed on that motion. I think it does make more sense that the child would stay, given the tragic nature of what brought this all about, the child would stay for some stability where the child had been living. I want to address some of the other issues that opposing counsel had raised, which we have touched on a little bit here, in the historical relationship. That was addressed by the court. I think the court understood that, and I think there's also a relationship. I think it goes both ways. There is a relationship between the minor child and Ms. Ridenhour that was even more recent. That would need to be taken into consideration as well. I also disagree with this issue of being grandparents gives somebody more legal standing as opposed to a non-parent or a non-relative, a non-legal relative. If it's parent versus non-parent, that's one thing. I understand that. That is very well established under the law. I don't think anybody would disagree with that, parent versus non-parent. But there is nothing that applies in this case. There's no authority to support this issue that the maternal grandparents have superior legal standing to a non-parent, to someone who's not a legal relative. And I think the juvenile court did address that issue. They've heard these arguments, and I think they made the correct decision, and there is substantial evidence to support what the juvenile court did on that grounds. And it's the same thing with the financial argument. The court should not take that into consideration. That can't be what drives who gets custody of a child, who has more money. That's not right. The juvenile judge addressed that, drew the analogy between, in a custody matter between parents, that's really not proper. I would agree with that. That's what I'm asking this court to consider well, that there's no authority to say that whoever has more money gets custody, and that this should be driven by financial decisions.
Well, that is true, but shouldn't the court still look at the means to support the child and the stability of the child? And financial means can make a difference with that. If you are unemployed and you don't have the financial means to take care of 3 children, that's not who has more money is a matter of the best interest of the child, to make sure that they're adequately cared for.
Yes, that's correct, Your Honor. That's sort of an important distinction that I want to draw as well, that under the best interest standards, the adjustment of the child to the home and the under 310904 F1, C, and D, those are important factors. Obviously, the child does have to be taken care of, but appellant is couching this in terms of who has more money. That's my interpretation of how this, one of their grounds for why the juvenile court erred in this matter. I've already touched on it a little bit, but appellant did sort of finish up talking about the local rule and the hearing and what would be the appropriate way to handle that. As I said, this isn't the time to relitigate those things. This isn't the time to discuss filing a motion to set aside or what the magistrate did at that hearing, which I think that is correct. Appellant went back and focused again on the emergency. Is it an emergency or not? As opposed to what the magistrate did at that hearing. So I think that's an important distinction. I think that makes a difference. So with that, Your Honors, I'm going to conclude. I'm going to ask the court to uphold what the juvenile court did in this matter.
Thank you for your argument. Counsel, you'll have 3 minutes and 15 seconds for your rebuttal.
Thank you. I'll kind of pick up where Attorney Hart left off. You know, when you're looking at an argument based on manifest way to the evidence, the court is required to look at the entire record, weigh the evidence and all reasonable inferences, consider the credibility of witnesses, and determine whether, in resolving conflicts in the evidence, the trier of fact clearly lost its way. So you are actually getting another shot at this apple, so to speak, because I'm asking you to do exactly that. Look over the whole record again. Review the testimony. Look at which witnesses were credible and not based on a sterile transcript. I know that's difficult, but that's what we're asking you to do. And with regard to that last section of what I just quoted to you, this idea of credibility of witnesses, that's crucial in this case because the people who are in the best position to talk about RP and how she interacts with people are the people with whom she lived. And Chandra Reidenauer, as you know, had some issues with her credibility specifically, and that's another thing we're going to go back to real quickly on this motion for the emergency order. She didn't support the motion with an affidavit, right? We've already talked about that. But she also did not advise the court that the child was not in danger, that the child was safe, that she was with her grandparents. And that's important because what she didn't say was as important as what was in the actual language of her motion, that this child wasn't in any kind of danger whatsoever. She also testified that prior to filing this motion, she spoke to Aaron Patterson's mother, Aaron, the deceased father, about actually giving RP to the mother, to Aaron's mother. She discussed the timing of filing the motion, and it was her understanding that if you file first, you're going to get the emergency custody. All of this suggests that this was set up by Chandra Ridenauer to get exactly what she got. She got what she wanted. And the other issue about credibility has to do with her testimony regarding her employment situation. She talked about not working because of a back injury and that she had been a nurse. But the fact of the matter is, her nursing license was suspended, and that came out on cross-examination. It was suspended because of improper conduct toward patients by Chandra Ridenauer. That fact was not disclosed to the court except through cross-examination. Those are very important facts to consider when you're thinking about credibility of witnesses. And we would ask you to do that in this case. Finally, how much time do I have?
40 seconds.
Okay. Finally, Your Honor, we would ask the court to weigh the evidence, review it just like the manifest weight of the evidence requires, the argument requires. And we would also ask you to look at this in the manner of fact finders and determine that the trial court in this matter erred and that this child should be living with and be granted custody to the grandparents, the Baumgartners. Thank you.
Thank you both for your arguments today. The court obviously is going to take time to look at the record and take the matter under advisement. We'll issue a decision in due course, and the clerk of courts will mail each counsel a copy of the court's decision on the day it is released. The opinions are also posted on the Supreme Court of Ohio's website.